Hi, I'm Ronelle Bridge from CTX Special Risks, your most dedicated marine insurance broker for both ship owners and charterers alike in Asia. The Evergreen grounding happened more than 2 weeks ago now, and I've received many inquiries from clients asking about the losses that flow from this and looking for ways to recover some of these. I've been speaking to my colleague, Charlie Hedgecock, based in London, and with COVID-19, I am not able to jump onto an airplane and come and discuss these issues with you face to face in your office. So we thought it might be a fun idea to record this video from down under this beautiful forest as a change of scenery, just to highlight a few key points for you to discuss internally and consider. And please feel free to get in touch if you have any further questions or if you would like us to consider anything in more detail. Let's focus on charter parties. But before I start, this video is by no means meant to be a legal advice. I'm merely giving you some key considerations in case it is relevant to your contract. Let's start with the impact that evergreen grounding may have on your charter parties. And the most prominent concern that I have received from both ship owners and charterers alike is, can my ship be placed off hire? Now, as you know, off-hire is a contractual creature, and what I mean by that is whether a ship can be placed off-hire or not, and for how long, will depend on the specific wording used in your off-hire clause. What types of off-hire events have you identified? Is it a period off-hire, or is it a net time loss off-hire? These are all specific considerations which one would have to review and consider on a case-by-case basis. So I am not able to give you a legal advice in this video. We would have to look at your specific contract. But generally speaking, under the most usual commonly worded off-hire clause wordings, I think the situation can be summarized as follows. Normally, in order for a ship to be put off hire, there has to be some inefficiency, something that prevents the full and efficient working of the vessel. This suggests that it has to be something related to the ship or the crew herself. If we look at the Evergreen grounding, the delay is caused by the grounding of another ship in the Suez Canal. In other words, this is an extraneous cause. The cause of this delay is something which is completely unrelated to the ship itself, her machinery, or her crew. And therefore, I think as a preliminary view, it would be difficult for a charterer to argue that the ship can be placed off hire under these circumstances. Another most frequently asked question I have received is that of force majeure and frustration. Can my charter party be terminated, or can I be excused from my responsibilities under the charter party as a result of force majeure or frustration? Let's start with force majeure. Force majeure is not a legal principle automatically recognized or implied into a contract under English law. Therefore, the question of whether you can rely on force majeure in this instance will depend on whether you have a force majeure clause in your charter party, and then specifically what details have been recorded as part of the force majeure clause. I'd be happy to look at any force majeure clauses which you might have in more detail, and I can advise you further on that. But what about frustration? Frustration is a legal principle implied into a contract under English law, and therefore, if you do not have a force majeure clause, can you still make an argument that the charter party should be terminated as a result of frustration? The key question when considering frustration is whether or not performance of your responsibilities have fundamentally or radically changed. Let's look at the facts in this case. Sailing from A to B via the Suez Canal might be the most usual, customary route for a vessel to take. The Suez Canal is now temporarily blocked. Does this mean you can no longer perform under the charter party? This has been considered previously by courts, and I think it's important for us to remember that there is still an alternative route, sailing via Cape Town. Yes, it will be more expensive. Yes, it will take longer. But I think when a court will look at this position and judge whether or not performance has become fundamentally or radically changed, it is still possible for you to deliver this cargo. It is still possible for you to perform. And therefore, I think it might be difficult, and I think it's unlikely that a court will view this case as one which is ripe for frustration. Another question I receive from many of the ship owners out there is concerns surrounding hull fouling. As you know, if your vessel is delayed or stationary in one place for a prolonged period of time, especially in tropical environments, the risk of marine growth forming at the bottom of your hull becomes a valid concern, especially where it starts affecting your speed and consumption of the vessel. So a lot of owners have contacted me asking whether or not a charterer can claim them in this instance and what can they do. The question of whether or not the vessel has adequately performed will depend on your performance warranties written into your charter party. If you do have these kind of concerns, please let me know. I would be glad to take a look at your charter party clauses and to walk you through these on a case-by-case basis. But for the purpose of this video, perhaps it's now become a little less of a concern given that the Ever Given has now successfully been refloated, and I understand that the backlog of the 400, 300 odd ships in the queue has now been cleared. What about other types of losses? What if the blockage of the Suez Canal has resulted in the late delivery of your vessel under the time charter party? Can you claim and recover some of your losses? What if that means that your ship has missed the laycan for your next very lucrative charter party? Can you recover the losses you have suffered due to the lack of employment or loss of employment of that contract? These are very valid and real concerns ship owners and charterers have, and I would be happy to consider these with you and walk you through the process. So please do get in touch if you would like to consider them further. This concludes my thoughts on some of the claims and disputes owners and charterers can encounter in respect of their charter parties. What do you think? What have I missed? Or do you have any other specific questions you would like me to consider in light of your contract? Please do get in touch. I look forward to hearing from you, and stay tuned. In part 2 of the video, I will focus on another important shipping contract, the bill of lading, and we will look at the types of cargo ship owners can expect to receive from cargo receivers.